dispute. Dad is helping another woman, mother, let me just say this, not a woman, but a mother of three, to take care of her kids. But the question came up, if you can help a mother of three take care of her three children that's not hers, why can't you do more for your own biological son? So before we dive into the video, I would like to thank you all for my new subscribers. We on the road to 6,000, and it's been a pleasurable road at that. Also, you can donate to this channel. Cash App is in the scroll. Let's dive into this video. This is the second or third video I've done from Judge Mary Morton, so I haven't done as many videos from her as other videos. So let's see how the outcome becomes.
Some statements regarding three non-biological children. Can you put some context as to what you're talking about? This is a hearing on the suit filed by the Attorney General's office.
The state would ask the court to take judicial notice of the guideline child support order signed on October 3rd of 2019 in this matter. The state will offer the pay record and Mr. DeLeon's pay stub into evidence at the appropriate time. Mr. DeLeon is in future pay on this matter to the amount of $275 as of November 30th of 2023. The state will show that Mr. DeLeon's income is $5,370.98 per month. Parties have agreed that health insurance, which is carried by Mr. DeLeon, the non-custodial parent in this matter, that the costs attributed are $50.17 a month for the health insurance just for the child in this matter, and $17.32 for the dental insurance per month just for the child in this matter. The state is requesting guideline child support based on one child in this action and 0 out, and the amount that the state has calculated based on $4,355.95 of net resources. 20% of that is $871 per month in guideline child support. And that is all for the state's opening statement, Your Honor. What is your relationship to the child?
I am his mother.
What is the name of the child?
Dallas Michael DeLeon.
What is the child's age and birthday?
Sure. He is 12 years old. He was born July 7th, 2011.
And how is the child insured for health insurance?
He is insured through his father's employer. So I think it's United Healthcare.
And how is the child insured for dental insurance?
The same through his father's employer through, I forgot. I don't know if it's Encompass or what.
And do you agree that the monthly cost for the health insurance just for the child in this matter is $50.17 per month?
I agree.
Do you agree that the cost for dental insurance is $17.32 per month just for the child in this action?
I agree. Yeah.
Has Mr. DeLeon been ordered to pay child support for this child in a prior order?
In a prior order, no.
In 2019, was Mr. DeLeon ordered to pay child support?
Yes, sir. Yes.
Okay. The state offers State's Exhibit A, the pay record in this matter?
Yes.
And Ms. Pennington, you've had a chance to review Exhibit A?
I did. Yes, ma'am, I did.
Okay. Do you have any objection to the pay record being admitted?
No, ma'am.
Okay. Mr. DeLeon, same question for you. Any objection?
No.
Okay. Exhibit A is admitted.
And Ms. Pennington, do you have any concerns about your email address and phone number being in this order?
No, I don't. Mm-mm.
Okay. State passes the witness, Your Honor.
Okay. Mr. DeLeon, ordinarily, you had an attorney. Your attorney could ask questions if they had any. Do you have any questions for Ms. Pennington?
No, I don't.
Thank you. All right, Mr. Driscoll, you may call your next.
And do you have any other biological children?
No.
Do you have any other children that you have adopted?
No.
Okay. Do you agree? How is the child insured for health insurance in this matter?
Dallas is insured through my employer.
How is the child insured for dental insurance?
The same through my employer.
Do you agree that the monthly cost to insure the child in this matter is $50.17 per month?
Yes.
Do you agree that the cost to insure the child for dental insurance is $17.32 per month?
Yes.
Okay. And what is your current job?
In the HR organization for Apple Incorporated.
The state offers into evidence State's Exhibit B, Mr. DeLeon's pay stub through August 25th of 2023.
And Mr. De Leon, do you have any objection to that document being admitted into evidence?
No, I do not.
Ms. Pennington, same question for you. Any objection?
No, ma'am.
Okay. Exhibit B is admitted.
And Mr. DeLeon, do you have any concerns about your address, email, and phone number being in this order?
I do not.
And the state passes the witness at this time, Your Honor, and reserves for a brief closing.
Ms. Pennington, do you have any questions for Mr. De Leon?
I do not. No, ma'am.
Thank you. All right, looks like the state has rested their case. So then now would be the time for any parties to present any of their own evidence or arguments. So Ms. Pennington, did you have anything else you would like to add? Any additional testimony?
I would like to say this. Not sure if this will help my case or not, but back in 2019, when I initially filed for child support and a custody order, my motive behind, filing was to obtain primary custody of Dallas. When we went to mediation, we couldn't agree to anything. And they said, well, there's a good chance that you may have to go in front of the judge. And there's a good chance that they may order back child support. And so I think 20% at the time of Michael's pay was $700 and some change. And he said, listen, Diane, they told us you have to come to agreement or you're going to go in front of the judge. So me and Michael agreed to the $650 at the time, which was less than the 20%. And I did waive the back child support. I do feel like I've helped him out. I feel like I have given him a break in a sense because, I do care about Dallas and his relationship with his father. Believe it or not, that's, still that Dallas loves his dad. So I didn't want Michael to essentially struggle and not be able to have a productive, healthy relationship with his son. So, there's one incident in particular where I felt I needed to go ahead and make this modification. And that was back on March the 7th, where I didn't have a lot of money that particular day. I only had like $40 in my pocket, and I had to take Dallas to see a doctor because he had ear pain. And to make a long story short, Michael had to end up giving me some money for the second visit because the doctor's appointment misdiagnosed him. And we ended up doing a telemedicine video call. So I wasn't there to physically pay them the copay. And Michael stated that he had called ARC to change the billing. So if I didn't essentially have the money, like the copay, I think it was $20, then we couldn't be seen. And so that really made me kind of process things and think that maybe, it is time for a modification. Of course, inflation's been hitting everyone hard. So he's not 3 years old anymore. There's a lot of extracurricular activities that he's involved in now, such as band and football, and he's now starting baseball. Food has gone up, and just like I'm sure it's hit everybody. Clothes, shoes, all that good stuff. So I just feel that if he is financially capable of taking on, 3 non-biological children, then I believe that he can help Dallas out a little bit more. I believe it's a $200 difference now. So
okay, and so Ms. Pennington, just so that we're clear, in part of your testimony, you indicated that you had deviated from the guidelines, but I'm looking at your order, and that was not an order with a deviation. The order ordered based on the findings of gross resources and the cost of medical and dental insurance. It was calculated at 20% of the adjusted net. If there had been a deviation from the guidelines, there would have been findings to explain that. So I wanted to just set the record straight that the initial calculation that was done in 2019 was based on the guideline
Oh, okay.
income. The second
Okay.
thing is you're making some statements regarding 3 non-biological children. So can you put some context as to what you're talking about?
Yeah. So I believe Michael married. I'm sorry, Michael. I can't remember. I don't know if it was this year. She does have 3 children that are not Michael's. They're not adopted either. That whole family lives together. So, and I believe he provides insurance for all 3 of those children. I could be wrong. But they all do live with Michael and his wife. So.
Oh, I see. Okay.
Yes, ma'am.
Thank you. All right. Mr. De Leon, did you have anything you'd like to say or add to your testimony?
Yes. In all honesty, the reason that I'm here today is because of the information that I was provided, and it may seem to, excuse me if this isn't right, because this is all new to me. But when we had the first meeting, they said, okay, here's your amount. This is what it is. My question was, okay, fine. But I would also like the entire document to be updated, our court order, as opposed to just the financial aspect of it. That includes the up-to-date parenting time. If Miss Pennington is being honest and saying that she cares about this relationship with myself and Dallas, I would be happy to come to an agreement right now. I will give her the 20% that she asked if we update to the newest standards for 50 miles and below, since that's how far away we live from each other.
All right. So, Mr. De Leon, unfortunately, the only pleadings that are before me are the pleadings that were filed by the Attorney General's office. It's a suit regarding modification of support issues. The Attorney General's office does not have the authority to bring any suits with regards to modification of custody of children, visitation, rights and duties. They are able to establish those orders, but if there needs to be changes because those non-child support orders are no longer workable, then that suit needs to be brought by the parents, not the Attorney General's office. You were advised correctly that the AG could not bring a suit to change the parenting time or rights and duties. Okay, so I am also not able to make any orders to change any of those issues as well, because those are not part of this child support court process. Now, I can refer you to the Travis County Law Library. It's online. It's a really good resource. Many people bring suits on their own, and they're able to go through the forms that are available online. You can also, I think, make an appointment to talk to a staff attorney there. I don't think they can advise you legally, but they can point you to the right direction. But there's also other legal resources that they may be able to point you to, so that if you wish to go that route, you can. And there's a lot involved in lawsuits, so I'm not going to get into a whole lot of detail for you, but I can refer you to that law library. So
Sure.
okay.
Yeah, it was very unclear in the initial information. It seemed like they were pointing me in this direction, because if I didn't think that, it would have been handled in the very first, and we wouldn't be here today, and I wouldn't be wasting your time.
Okay.
So, yes, I hope that what Ms. Pennington says is true, and if that is the case, I believe we'll have no problem And I'm not asking for the world. I just want the new standard. Um, just because of how far away Dallas is now, it makes it very difficult for weekday time to be any time at all, based off of where we live. Um, so if she is true to her word, we can close this out and we can stick to a standard of 20%.
It sounds based on what you're testifying that the calculation as suggested by the Attorney General's office for guideline support and what they're requesting, you agree to that amount.
It seems like really that's my only, you can correct me if I'm wrong, but I don't really see uh, much else from that. So if this is kind of the only thing my option is, and there's nothing else available to me, I don't know much about the second process. If this is null and void and we have to start all over when I start the petition for the modification through the library, I've obviously never done that before, so I don't know if that makes us start this entire process over.
I'm not sure I understand your question.
Oh, I'm sorry. You mentioned the law library, where you have to do a petition to have the visitation changed.
Well, what I think what you're maybe getting at is whatever orders are in effect now, they remain in effect until another order that makes that changes those orders. So in this hearing, the state is requesting a change in the child support amount, not so much the change in the medical and dental coverages, because it seems like you currently have those coverages and you had them. They were court ordered in the current order that was done in 2019. And so it appears what the state is requesting is a change in support. Now, what I haven't heard is their final argument as to when it should become in effect. I'm sure that they'll get to that, but the court can, under modifications, make the change effective to a date other than, well, it can go back. So I can order that this support be effective November 1st because all parties were served in October. And I believe this is the first setting. So I believe it's the earlier of. Am I correct, Mr. Jurisco?
That is the state's understanding. Yes, Your Honor.
Okay. So, so at this point, I'm not sure what the state will be advocating. I'm sure they'll state that in their closing, and then I'll make a decision about that. So it doesn't, we don't go back. It doesn't wipe out everything that was done in 2019. So orders will become in effect from the effective date I order, and then that will be when the new support needs to be to start.
Sure.
Okay, Mr. Jurisco, do you have a closing argument you'd like to make, sir?
Yes, Your Honor. The state wants to confirm future pay of $275 per month as of November 30th of 2023. If I were to do that, I'm trying to make sure. I mean, the state was going to ask for this to start December 1st of 2023, unless the court wants to start new child support as of November 1st of 2023. The state defers the court's judgment to that effect. And the state asked for guideline child support of $871 a month for guideline child support, and for Ms. DeLeon to carry health insurance and dental insurance. And if we're going to start as of November 1st of 2023, then the state would have to take a different judgment date on the pay record, and that would be October 31st of 2023. And that amount of future pay would be $325 as of that date if we're starting current child support at November 1st of 2023. And that's all for the state's closing statement.
For final orders, finding that Mr. DeLeon is paid ahead $275 as of November 30th of 2023 in current support. Based on testimony provided by the parties and the evidence presented, I find that the modification should be granted. It has been 3 years,
Yes, ma'am.
over 3 years since the last order. So, and the difference in the calculation differs by 20% or $100. So the guideline amount is suggested at $871. I find that that would be in the child's best interest based on the testimony provided. And so guideline support of $871 is ordered, and it's effective on December 1, this month, 2023. As to, I don't think there was special restrictions as to disclosure of information, so that isn't ordered. I am waiving court costs against Mr. DeLeon, so he'll get a break on that.
Thank you.
All right, you're welcome. Okay.
She demands money.
All right, you see how that went. Mom said it wasn't fair that he was taking care of his wife's 3 non-biological kids, and she felt that she was trying to be a little cordial with that, but now it's time because fees have gone up and he's not a little kid anymore. Band, sports, different things like that. So nevertheless, thank you for all my new subscribers. Comment below, subscribe to the channel, hit the notification bell. You can support the channel. Cash App is in the scroll. Once again, we will see you in the next video, and we're going to keep the heat coming.